now, and I will turn it over to our board chair, Lynn Marshall.
Thank you, Rachel. Hi, everyone. I'm Lynn Marshall. As Rachel mentioned, I'm the chair of the Open Meetings Compliance Board for the state of Maryland. We're here today for a special meeting to discuss proposed legislation sponsored by Delegate Carr. And Jacob, are you on? Can you introduce yourself, please?
Yeah, hi, this is Jacob Altschler. I'm a member of the board as well. And yeah.
Thank you. So with Jacob and I,
So there's not much else to add for me. I'm not the chair, right?
well, I don't know about that, but let's if we, it might be easier for people when reviewing the recording for minutes. Jacob, why don't we try to remember to identify ourselves each time we speak, even though our voices sound different. So this is Lynn that I've been speaking. So as I mentioned, we're here to discuss this, for Jacob, you and I, to discuss this proposed legislation. The two of us do constitute a quorum. We're a 3-member board. We currently have one position vacant, but so we do have a quorum today with Jacob, you and I here. I would say as well that we are not taking comments today from members of the public. So any members of the public who are on the Teams call, including members of public bodies, we'd ask that you make any comments that you have directly to the sponsor of the bill or to the to whatever legislative representatives you choose. So Jacob, I believe in my time on the board, we've only discussed proposed legislation. Maybe this is the 3rd time, but my understanding of our role and our purpose in providing input on proposed legislation is primarily to consider the proposal in light of the overall meaning of the act and purpose of the act, as well as the effect on potentially on our processes and a complaint process and our work on our board, et cetera, which is why we're requesting that members of the public make their comments on effect on the public bodies, et cetera, directly to the legislature. So this these proposed amendments to the Open Meetings Act, there are 4 of them under I believe it's LR. The number of the legislation. I don't have it in front of me.
I think it's 716. I think it's
LR 716. Is that right, Rachel?
Yes.
Okay, thanks. Sorry about that. So there are 4 proposed amendments. The first being extending the time that a public body has to retain notices of meetings. The second, requiring that a public body post its closing statements online or provide the public with electronic copies upon request. The third, extending the time that a public body must retain closing statements. And fourth, requiring that a public body that does not post minutes online provide electronic copies of minutes upon request. So as far as the retention of meeting notices, the proposal is to extend the retention period from the current 1 year that's in the statute to 3 years. The Open Meetings Act requires that before meeting in a closed or open session, a public body has to give reasonable advance notice of the session. And currently, as I mentioned, that notice, the public body has to keep a copy of that notice for at least 1 year after the date of the session. And the delegate proposes to change that. That's section 302D dog of the general provisions article in the Maryland Code. He proposes to change that to require the public bodies to retain meeting notices for 3 years. Jacob, I don't really have thoughts one way or the other on that as far as the purposes that I've mentioned earlier. The second proposed amendment has to do with closing statements and posting them online. Before a public body meets in a closed session, the Act requires, among other things, that the presiding officer make a written statement for the reason for closing the meeting, listing topics to be discussed. There's not a requirement that a public body post closing statements online currently. So Delegate Carr is proposing adding a new subsection to that part of the statute. That's section 3305D dog, requiring a public body to post its closing statements online or provide the public with electronic copies of closing statements upon request. And he's saying that if the public body, so it says the proposal is to the extent practicable, a public body shall post online the written statement required to be kept, and if they don't post the written statement online, they would be required to provide an electronic copy of the written statement on request to a requester within 2 business days of receiving the request. And Jacob, I didn't really, in my preliminary thinking this through, I don't really have, thoughts in particular on the requirement that they be posted online. But the 2 business days worries me for a few reasons. It's a very short period of time, frankly, for public bodies to do anything, but and I'm not trying to make light of it, but 2 business days is not very long. And without knowing the reason why that electronic copy would need to be posted so quickly, and that's up to the sponsor and the legislature to decide. It just worries me to require that statutorily. So I'll just say that at this point, and I'll go through the rest of these, Jacob, and then I'd like to hear your thoughts, because there's another one with the 2 business days as well. So the third proposed amendment is extending the period from 1 year to 3 for retaining closing statements. And that's under section 3305D dog 5. That would require the retention of closing statements for 3 years instead of the current 1 year. And that I don't really have thoughts one way or the other about that. The fourth and the final proposed amendment is providing electronic copies, has to do with providing electronic copies of minutes. Currently, the Act provides that as soon as practicable after a public body meets, it's required to have minutes of its session prepared. The delegate proposes adding a new requirement that if a public body does not post minutes or recordings online, the public body shall provide an electronic copy of the minutes or recording on request to a requester within 2 business days of receiving the request. So there's the 2 business days again. And apparently the reason for this requirement is that during the COVID-19 pandemic, some government offices closed to the public, which made it impossible to inspect meetings in person. And that's what the Act currently provides for, is that minutes of the public body are public records and have to be open to public inspection during ordinary business hours. So that's the reason for the online thing. Again, I'm not sure what unless Rachel or Jacob have other thoughts or information, I'm not sure what the reason is for the 2 business days, but that concerns me for a few reasons. One is, Jacob, as Rachel has pointed out to me, this proposal could create a conflict within the Act, which permits a public body to take a reasonable amount of time to review draft minutes for accuracy and approve the minutes. And generally, the board has said in prior opinions that the public body should prepare minutes on a cycle that parallels a public body's meetings, with the only lag time being that necessary for drafting and review. So if public bodies are meeting monthly, they generally comply with the requirement to prepare minutes as soon as practicable if they adopt the prior meeting's minutes at the successive meeting. with this proposal, besides the 2 days, which I'll get to in a minute, if a member of the public requests an electronic copy of the minutes immediately after a meeting, it might be impossible for the public body to comply with the proposed new requirement of providing those minutes within 2 business days because the minutes might not be finalized for several more weeks. So what I was in thinking that part through about the timing of the request and the, our prior opinions on what as soon as practicable means, I was thinking that if the proposed amendment added the word, adopted, that the minutes, once they're adopted, the requester can request them, and then for whatever time frame the legislature thinks is appropriate. So that's one thing that I wanted to flag in our response. If we draft up a letter after we discuss this, Jacob, that's one thing I should flag. I agree with Rachel on that for Delegate Carr, and that was one thought I had about just adding in the adopted minutes as opposed to for the timing of when somebody can even request them. The 2 business days, again, here, I worry about for the same reason that I've already stated, that just doesn't seem reasonable to me. Now, I don't know that it's, I do think that could cause, and frankly, any specific time in the statute for the public body to have to respond will likely cause more complaints to the board, and that is what it is. But 2 days seems a really short period of time to me. Now, I don't know that it would be our role, or it would be advisable for our board to suggest a certain time frame. I don't know that I'm comfortable with that because, for not knowing the reason for this, and for what I've stated earlier about our role and our purpose in reviewing legislation. But I think we should flag that in our input to Delegate Carr. So that's and overall, Jacob, my other thought is to to not take a position on the give that input to Delegate Carr, but not take a position supporting or opposing the proposed legislation, but flagging those issues and maybe making suggestions about adopted minutes and that time frame issue, which I wasn't thinking that I would necessarily be comfortable saying, yeah, it should be 10 days or it should be 15 days, because I don't know the purpose of the 2 days. We could suggest, within a reasonable time that the public body would have to provide the minutes if they're not posted online to a requester. But that again would, we would probably end up having to issue opinions interpreting what that means in a certain set of circumstances. And that, if the legislature wants to do that, that is what it is, and we'll deal with that. But my thought is primarily to flag it and to point out that 2 days, if you agree, Jacob, seems very short to us, a very short time frame for a statute to require a response from a public body. So those are my thoughts overall. So what are your thoughts, Jacob?
Yeah, Lynn, Jacob here. So I think you covered most of the concerns that I had with the proposed legislation as well. I will say, just as a general matter, and this obviously relates to our duties on the board as well, like you, I'm generally hesitant to make suggestions on proposed legislation without getting a look at, the universe of facts implicated as well as the reasoning, because that obviously helps us understand the, reason for the proposal. Aside from that, regarding the extra 2 years that public bodies would have to retain the closing statements as well as notices of the meetings, like you, I'm not sure where that term came from, and downstream of that, obviously the the purpose of requiring them to retain them is, I would assume, to request them down the line. And that obviously can also implicate matters for the board where there are issues with that. So it would be nice to know the reasoning behind all these proposals, I would say. I'd say the most, glaring issue is the one that you discussed regarding the minutes and recordings that have to be placed online, given the fact that, public bodies have a bit of leeway as to the schedule on when they release and post those. I'm also in agreement with you on the 2 business days issues. I'm not sure where that timing came from, and like you said, that's a pretty quick turnaround for public, and I would say private bodies as well. So that could increase the burden on public bodies, and then as well as increase the burden on ourselves. And in general, again, I'm okay with having more complaints if they're legitimate complaints. So the fact of the matter is, it would be nice to know the reasoning behind it. So those are kind of my general thoughts, and for the most part, actually, completely, I agree with the points that you've made. I think they're all very, well stated.
Okay, thank you. And this is Lynn. And Rachel, my recall is we did, Jacob, I asked Rachel to reach out to Delegate Carr to see if he wanted to discuss the amendments with one of us, not with a quorum, but with one of us individually in advance. And I believe that he said that, basically the legislation speaks for itself. So I hear you, and I agree that it would be nice to know more about the reasoning, and absent that, and also with frankly, my goal of hopefully not having to have successive, serial meetings on this legislation, if they, a change is made here, a change is made there. I guess my thought at this point is to draft up a letter for the board to send, saying that we're not taking a position on the overall legislation, but that we want to point out two issues. One being the timing of people requesting minutes. What do you think about suggesting that they add the word, after the minutes are adopted in there, or do you think that's like even overstepping what our role is here, and that we should just flag the issue and then let the sponsor and the legislatures decide how they want to change that language? What do you think about that, Jacob?
Yeah, Jacob here. I personally wouldn't suggest language for them. I would personally just flag the issue.
Okay.
Again, given the background of the conversation that we just had, that's my personal take.
Okay,
Do you
that
agree,
sounds
Lynn?
fine. That sounds fine. This is Lynn. I agree with that. So why don't we plan to do that? Rachel, maybe you can draft up some language for us for flagging that issue, and then on the two days, Jacob, how would you propose wording that? Just that we have concerns both for the board's work, as well as burden on the board and everyone else for that quick turnaround, or how would you? What are your thoughts on that?
Jacob here. I would definitely address the 2 business days. I would say that the delegates' proposed amendment itself, the one regarding posting online the written statements, actually begins with the language "to the extent practicable," which even implies that at times it may not be practical for a public body to post the written statement online. And continues to go on and require 2 business day timeline, which almost seems to be counterintuitive. And if it's not practical for you to post it online, is it really practicable to, follow a 2 business day timeline? I would just flag that again. I wouldn't suggest anything, but I would bring that to their attention.
Okay. That sounds good to me. I agree with that. Rachel, does that give you enough input for the drafting of those two issues in a response or an input letter?
Yeah, this is Rachel. I think that's enough. Unless, do you want to say anything more about why you're not taking a position? Do you want to restate what you've said here today, just about your sort of philosophical view of the board's role and the limited role you see the board having in proposing specific legislation?
This is Lynn. Yeah, I think so. I mean, honestly, and I haven't, Jacob, and I haven't dealt with many of these on my time on the board yet, but my general thoughts on as far as legislation go is that unless the board is proposing legislation, I'm kind of hesitant, if not averse, to saying we support that, or we oppose that, which we have done, but that was in a certain circumstance. But generally, if there's, I like the idea, and I believe in some, at least one letter that I've seen from a prior board about proposed legislation. I like the idea of us remaining neutral because it's not our role to legislate, but to point out to the legislators potential conflicts with, or things that could be rendered unclear or conflicting, as you've pointed out, Jacob, with the current language in the statute, and also the effect of proposed amendments on the process, on transparency, and on our work. So, Rachel, expressing that, I think, is reason why we're not taking a position, I'm comfortable with. What are your thoughts on that, Jacob?
Jacob here. Yeah, I think that's well put, and yeah, I agree with that.
Okay. Now, what might happen after we send the letter is that we'll get, another version, which might require us having another meeting. But if we get another version that, I mean, do you have strong feelings, Jake? I'm trying to figure out a way to not take everybody's time again if we don't have to. If we get another version that is not substantively hugely different, I mean, my thought is that we say what we have to say about the concerns that we have, and then what the legislature does with that input is kind of up to them. Do you agree with that, Jacob, or would you prefer to have another meeting anytime if we get any revisions to this? Does that make sense?
Yeah, Jacob here. I guess it's a little difficult for me to answer that question because I don't know what sort of revisions there would be.
Yeah.
In general, I'm okay with meeting again, as I assume you would be too. Just judging on the past, if I remember correctly, like you brought up, the revisions sometimes are pretty minor. And don't really change much in regards to the scope of what the amendment would affect. But yeah, that's a hard question for me to answer just in general because the changes to the amendments we don't really have much control over. So I don't know what there would be there.
Yeah, I hear you. And I guess this is Lynn. I hear you. And I guess I'm thinking, like, this says 2 days. And if they change it to 10 days, I don't know that I would have anything more to say about that, I guess is my point. Would you, depending on when the time frame is, or without knowing if they tell us a reason, then I would think we would need to have another meeting. But if we don't get any more information other than, some change, like changing it from 2 days to 10 days, I don't know that I would have anything more to say. What do you think? Would you?
Jacob here. Yeah, no, I agree with you. I would not have much to add. Again, not knowing the reasoning behind that and the potential issues that can be inherent in that new timeline. So I would be in agreement with you.
Okay, this is Lynn. I just want to get your thoughts on that in case that comes up again so that I can decide whether to convene another meeting if we get something more. You know what I'm saying? So I think, Rachel, is there anything else that we needed to talk about? I think that we've, Jacob, the it doesn't sound to me like you want to say something in particular about extending the period. Is that right? Just not take a position? Is that correct?
Jacob here, yeah, that is correct. Yeah, that's correct.
Okay, and I agree with that. Okay, Rachel, do you have any comments or questions for clarity on what we're thinking as far as a letter giving our input?
No, I think this is Rachel. I think I understand everything you want to say in the letter. So what I'll do is I'll draft that letter and I'll send it to both of you. And assuming that there are just minor stylistic edits, we can go ahead and send it. If for some reason when you see the letter, if you feel like there's something substantive that needs to be discussed further, we'll obviously have another open meeting for you all to be able to discuss that in open. But I think I have enough to go on and I'll be able to draft a letter for your review.
Okay, understood. This is Lynn. Thank you. Thanks very much, Rachel, for doing that. And thanks everyone for taking the time to join the call. And thank you, Jacob, as well.
Jacob here. Thank you, Lynn, and thank you, Rachel.
All right, thanks. So if Rachel, you don't have anything else, then we're adjourned. I hope everyone has a good evening.
All right. Thanks, Lynn. Janice Clark, if you're still on the call, is there anything I need to do to save the recording in a special way to find it again?
No, this is Janice. Once you end the recording, you should get an email and you'll have to work with Fritz to